Hey peeps, so we have an interesting video today, uh, straight from the Solid Citizens. This fool right here, straight off of Brokeback Mountain, no clue, brainless, tries to play a interesting trick with this Lake Forest court system. What is that? Oh, I think that her name is Jennifer. Uh, Using the basic tools of solving citizen techniques that fall horribly, using the uh, uh, you don't always. There's not. It depends on what you're charged. That's not always a victim, and if it is, sometimes the victim is the state or the county. But he doesn't quite understand this, so I'm thinking he's new in the game. And it doesn't really work out the way he wants to, and he's using this weird technique of trying to avoid prosecution by claiming he's not. Well, before I go into all that detail, let's go ahead and open up this beautiful bean footage.
Right.
I have concerns over Prosecutor McDonald and her ability to understand what's going on, but that's okay. I'm not going to raise any challenges or anything against that.
Well,
I just want that noted. Yeah. So for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary.
The benefit. Let's go ahead and continue before I go.
I had mailed out some paperwork over to the prosecution as well as submitted it to the courts. Were you able? Have you received those, ma'am?
So I've received two motions from Mr. Schuster. Have you?
Yeah, the two motions as well as the affidavit, as well as the certified copy of the. So you got that paperwork? Were you able to read it?
I have two motions. One was, both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
It's on the back.
The affidavit was received at the same time that the motions were submitted, and so.
And I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I
emailed to Ms. McDonald this morning.
You did? I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit proof installed.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr.
And
Schuster.
so those were sent over.
I often find it funny when they often use the word dismissal. They want to, before even going into the case, they want to immediately dismiss it. For what? We still have to investigate. We have an officer that got you. We have the evidence that you didn't, and you want to go straight to dismissal. You want to bypass the whole judicial system and say, I don't, and let's go ahead and do it. Even if you're innocent, you still got to go through the process. This is a broken mindset of these sovereign citizens. They're like a broken Tootsie Roll. All right, let's go ahead and continue this.
Hold on, Mr. Schuster.
As well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
I just wanted to make sure I said that. Thank you.
Madam Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today. Except the orders from Mr. Bailey Garrison. And the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's going to be plenty of time for you to talk.
Yes. Thank you.
Madam Clerk, sending it again to your email, Ms. McDonald.
It's 11:06.
Also, the prosecution, I've never received anything from you as well. But there is an email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court. So they were physical copies because there's digital evidence as well. But
Well, I just have never received anything from you.
it went out to your mail. So I don't know what to tell you about that.
Did you check,
Yeah.
Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that that wasn't his address, so we sent out another packet of full discovery.
So this fool is using what I call the chase effect. He's giving the courts multiple different addresses in an attempt to elude prosecution. And when he says, "Oh, that is not my correct address," gives them another address, and then when confronted and back going into court, he's going to sit there and say, "I never received it. This is my new address." Let's see how the court's going to handle this craziness.
To him, to the address that he updated. Let's see, the one on Kenyon Street.
2318 California Avenue.
You gave us on January 27, 600 Southwest Kenyon Street, apartment G201 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest Kenyon Street, apartment G201. So
the same day that
that was the
Mr. Schuster,
denied subject matter jurisdiction?
Mr. Schuster, is that the address you gave on January 27th?
I don't recall, but I do have.
I recall. This is what happens when you let your children eat too much lead paint. This is what happened when your kids eat too much lead paint. They get dumb like this. Now, let's go ahead and continue. Oh my God, this was stupid.
Somewhere she can send it to. So
well, we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it, and I don't recall. So I'm giving you an address, but
You recognize that address?
which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 600 Southwest Kenyon Street, apartment G201 in Seattle. The one prior to that he requested was 1005 North Cleveland Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Now we know nobody moves that damn often. This dude is trying to play the Jedi mind trick.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that
She did. It was on the record. She denied subject matter jurisdiction. She didn't deny my motion. That wasn't until later. But regardless, you did receive the two motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald? Have you gotten that yet?
Perfect. Have you had a chance to read over that, Miss?
So obviously Ms. McDonald has not had a chance to read over it.
Oh, I was referring to you, ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
Well, from the very beginning of this matter.
Remember signing this piece of paper saying you were representing yourself?
From the beginning,
That's not my question, Mr. Schuster.
Well, I'm answering your question. I would like
I
to
don't want a
speak.
narrative, yes or no,
Thank
do you
you.
remember signing this piece of paper?
I don't recall.
Okay,
I
well,
don't know
your
what paper you're
signature is
showing me.
here on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just very
Schuster,
hard to read.
He loves to play stupid when it benefits him, but when it not. Notice how he often says, "Did you get my paperwork?" or "Did you get my this?" But when it comes to the courts, "Oh, I've never gotten anything." So his mindset, like most sovereign citizens who want to play this Jedi mind trick of, I know better than the courts. Let me manipulate the courts. Let me take up resources and time of the courts, even though I know I'm guilty. This is how broken their mindset is. And most of them, if you look at most sovereign citizens, the root cause is their license is suspended. They got some kind of issues going on with them. They don't want to pay to get it fixed, and they don't want to be. They don't want to be Americans. My thing is, if you don't want to abide by the rules of the United States and the states or the rules of the states you live in, we can send you somewhere else. Go, and you will have to abide by their rules. But any which way, let's go ahead and continue.
Because it's blurry
Okay.
from this
so
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you are expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
Well, this isn't the trial.
Nonetheless, I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject matter jurisdiction in this case will proceed. So those motions are denied.
The whole right to travel is nonsense. And so, when the Constitution was written, there were no cars. So, the right to travel doesn't, is not applicable to cars. The right to travel is the right to be able to go from state to state without having to pay penalties, fines, or anything else. So, which means if you live in California, you can go to New Mexico, or you can go to Arizona, or you can go to New York or Jersey, and treat it as if you were a citizen in each and every state. You can travel by plane, automobile, As long now, the automobile part is where it gets tricky because states are self-governing to a point where, as long as it doesn't interfere with the Constitution, so a state can require you to have a license to drive a car. If that's the case, that means you cannot drive the car, but you can still be transported by automobile. You can also take a train. You can also take a bicycle. Whatever the limitations of the states are, it varies from state to state. And it's not even the right to travel. There are, as long as the state's laws can be more restrictive, but they can't be less restrictive than the federal laws. So, the right to travel, you do have the right to travel, and no states not allowing anybody to do that. But they want to take it a step further, saying the right to travel, I also have the right to drive an automobile or a motor vehicle, and that should eliminate the need for a driver's license. No, it doesn't. Because you can still travel, you just can't drive. You can still take a bus, plane, or a plane, Uber, Lyft, fuck Lyft, cab, whatever services that you want to get the point A to B. But the states say, hey, you need, in order to drive, to make the public safe, you need to have a driver's license. This is where these dum-dums don't want. They want to take part of the Constitution, take that part, and the other parts where it refers to the states, they want to throw in the trash. But let's go and continue.
I am also not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
It was never a third. In the beginning, they had the correct address. It's no longer the correct address.
then it's
And
not the
so-
correct address. If it's no longer correct, then it's not correct. You've given a
Well, as of
address.
recent, as of literally not that long ago.
So when
So-
Then you should have gotten all your documents and you claim you don't have them. He's lying. He's using the mail system as a way to not get his documents so he can prolong this and not get his due process because he's just what he's doing is what some people do in traffic violations. You keep prolonging. So you get a traffic violation. You do this. You call in and say, "Hey, I can't make it this day." They reschedule it, and a week before then, or a few days before then. Hey, I can't make it. And what happened is that the police officer gets so irritated that he just don't even show up for that appearance, especially if the only date that he has is just coming to yours. A lot of times they won't show up at all. That's what he's attempting to do. He's hoping that the system will get irritated to the point where they would just say, "I'm done," or they give him a reduced sentence or a reduced fine, or they would lower whatever the charge he has because they're tired of playing this game. Let's see if this system is going to deal with this knucklehead's nonsense.
When did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
It's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
And this is a court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
I see.
We are on the record now.
I like you, Judge.
So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that everybody has the correct information.
Anybody?
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest.
You believe?
D.
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that.
Wait a minute. If you live here, you don't know how they label it? This, again, he's trying to play these Jedi mind tricks, giving a false address or address that he don't live at, most likely. Some family address or some other people gonna get his documents so he can come back to court and say, I didn't receive it. Let's see how they handle this nonsense.
Seattle, Washington 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
Family.
I don't believe it either. Good catch, Judge.
And so, just so I'm clear, you're saying that the right to travel and privacy is not a federal matter, and that
I'm
you're
saying
saying
that-
that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington, and that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty, and a right because no person shall be deprived of life, liberty, or property. You're saying that doesn't.
Yeah, this a typical technique with sovereign citizens is they try to use that to also cover automobiles. He has the right to travel. No one's taking that away from him. But you don't have the right to drive a automobile or a motor vehicle or however you want to phrase it. This is what you call improper use of the Constitution. The state is not allowing him to travel. There's only certain ways you can travel, and automobiles without a license isn't one. You can travel by bus, airplane, helicopter, fucking horseback. If you want to go hire yourself a mule, you can jump on the back of a mule. But you can't. In most states, you cannot just jump in a car and say, I have the right to travel," and use that as an excuse. This is what we call broken ass logic, where they improperly use the Constitution to benefit their ideology. To say, yes, I have the right to travel, and I also have the right to drive a car, and I have the right not to have insurance, and I have a right to not to have registered plates, and I have the right. No, you don't. You don't. You have the right to travel. You do. You can walk on your damn 2 feet. Let's go ahead and finish this up.
That isn't a federal matter.
I'm saying that there are multiple layers of jurisdiction that involve travel, and that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances. So what do you want to do on your case today, Mr. Schuster? Is it your intention to go to trial next week? Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to
This
appeal
court
any ruling from
lacks
this
the
court.
authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this must be dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you are
Most definitely.
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald.
Well, as I've stated, this case should be moved to the proper courtroom, which it's not.
In the proper courtroom, and that's not happening, and Mr.
If it's not transferred, I do, it should be dismissed.
I'm not entertaining further motions to dismiss. Ms. McDonald, go ahead.
Yes, and Mr. Schuster, I sent to you in the chat because that is the only way for me to get that to you right now.
Oh no, you have my email. You got the information on the motions there. So you have the email listed above. I don't really know how to use Zoom like that, and so sending anything.
Again, playing stupid. Zoom is not that difficult, and if you don't know how to use it, you can always ask or research it. It's not that difficult. Click. It's not. You're not using command line. You're fucking using a GUI. Point, click, point, click, point, click. Again, the broken ideology of just sovereign citizens just absolutely despise me. I don't understand. Just get your shit together and you'll be cool. You'll be good. But they want to live like criminals and not obey by the laws that's governing by the state or the government and say, I want to do what the hell I want to do, and it's okay.
Over through chat like this is just it's difficult. So email would be the best way if you want to get that to me faster. But of course, you have an address now that I'd be able to get the mail that you're saying you've sent already. But no worries. So
I'm using Zoom the same way we used it at the last hearing when we sent you documents and you were able to chat back and forth with me. So it's in that chat.
We didn't have a back and forth.
We did.
Chat. No, we didn't.
So there is a document in the chat for you to open and take a look at, and that is the city's plea offer. We are agreeing to dismiss 2 charges for a plea to 1 with a credit for time served recommendation. So if you'd like
as I stated, you can email it so that I can properly see it, because that's the best way for me to do it quickly, because I don't really know how to use this chat function in Zoom.
It's 2025. The function of Zoom chat is not difficult. You have to be a bumbling idiot not to say you don't know how to use it. Again, he's playing these Jedi mind games on the court system, or attempting to do it. Now, in the court system, I do have some problems with him. Given these, he has 3 charges. She wants him to plead guilty to 1, and she's willing to get rid of 2. Okay, I understand that pre-bargains and trying to, not use up court resources. I understand all this. But this is not going to fix the problem of sovereign citizens. You need to throw the fucking book at them. I mean, you need to, every law book you have, you need to hit them straight in the head with it, because they're not going to learn because they think they can circumvent the court system by using this stupid-ass logic they come up with, saying that, subject matter jurisdiction, and you don't have jurisdiction over me, and I'm a special person, and I'm not a citizen. If you're not a citizen, then take your ass out the fucking country. Even if you aren't, if you are a citizen of the United States, you leave the United States, go over to, I don't know, Spain, you have to abide by the rules of that country. You don't have special rights. You're not a diplomat. You have to abide by it. So it doesn't matter where you go. You still have to abide by the rules of that country. And how sovereign citizens think they somehow special or indigenous people, which they aren't indigenous. Does he look like a Native American? And even Native Americans are not, even though they're indigenous, they still have to follow the laws outside of the reservation. Yeah, you might be able to drive whatever the rules are in the reservation, but once you leave there, you have to abide by the laws of that state that reservation is located in, and you can't just laddy-dally say, I'm going to do what the hell I want to do. And this is the problem with the broken logic with sovereign citizen. And too many of them think they know what the court system is, and they don't know jack shit. They go online, they read this nonsense, and they promote the dumbass ideology that they believe in that gets them nowhere. And I've actually talked to people, oh yeah, they win all these cases. Like, no, they don't win shit. Just because they dismiss a case, or they lower a case, or they make a plea bargain for a case, doesn't mean that you're not guilty. It just means they're trying to not spend a whole lot of resources on the court side to get you convicted because they don't find out it's worthwhile. They would rather have you convicted of one charge than have to spend hundreds, if not thousands of dollars to get you 3 charges when you're only going to pay only a couple $100 for it. They're looking out for the taxpayers. But either which way, you got to get punished one way or another because you cannot continue doing this nonsense.
Ms. McDonald, do you have the ability to email it to him?
I'm looking for the email.
Yep, it's at the top for the motion to show cause, as well as the bottom of the motion for dismissal. But, I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
So we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, they can email me. I don't mind.
Then
Yeah.
spell out your email for Ms. McDonald.
Do you know how to spell my last name, Miss McDonald?
Please just spell it out. Let's just be as clear as possible.
Well, it'd be my last name .jon@icloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Miss McDonald?
Yes, I am.
Okay. SCH.
Okay.
Can you hear me?
Yes, I can.
Oh, okay. I wasn't sure if you could hear me. I know we've had trouble communicating over Zoom because sometimes you can't hear. But SCH, USTER.
Okay.
You got that?
Yes.
Oh, okay. So my last name, John, Jon.
Okay.
You got that?
Yes.
Oh, okay. At iCloud.com.
He's so special. Oh my God, this dude is good. He's a special kind of stupid, but let's go and continue.
And, it's actually pretty ironic that you say that about the email, but then mailing addresses are said out loud too, so that's just kind of ironic.
But they confirm the addresses, and they send the stuff, and you sit there and tell you that you don't get it. It's not ironic. It's that you playing the Jedi mind trick, trying to give up addresses. Then, I never received it, so you can get another court hearing, trying to stretch out the statute of limitations to the point where you can't get convicted. But I think this judge, Miss Grant, is going to put a boot straight in your back where it needs to be. Because this sovereign citizen nonsense needs to stop. It really does. And this ideology that I want to be a criminal and I don't think I'm on top of everybody else, that needs to stop. I'm a serious advocate of that. These sovereign citizens need to have the boot put straight in their back. You caught with driving out a license, you have no license, you have a registration that expired 3 years, and you don't have. Lock them up, take that car, put it in the impound slot, and then let them figure it out later on. Because until you start setting up rules to punish these knuckleheads for the stuff they're doing, and they know they're doing it, and they think they have a constitutional right to do it, which they don't, then they're going to continue this broken ass ideology. States need to change their laws to punish these imbeciles for what they're doing. Let's continue.
So far,
that you would mention that.
yeah, well,
But
as I said at the beginning,
nonetheless,
as I said at the
it's
beginning of
okay.
court, everything's being broadcast on YouTube, but
Oh, I know.
we
But
need to
nonetheless,
respond to the fact that you have changed your address repeatedly. So Ms.
nonetheless,
McDonald
that's
is
just
emailing you,
ironic.
Ms. McDonald is emailing you a copy of a plea offer.
Cool. You said you were going to send that in the mail as well, or
No,
information in the mail.
it's not coming in the mail. It's coming via email right now. You have the
Oh,
opportunity to
I'm
review
talking
it right
about
now.
like the other information she was.
No, that's already been sent in the mail. You need to go to wherever those addresses were to get your discovery.
Mm.
Yeah.
The discovery was sent out on February 10th, approximately a week and a half after you gave that address on the record.
On the record, when the judge denied subject matter jurisdiction
When you were in court on the record.
on that day, when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
What the hell does that have to do with your address? Really? What the hell does that have to do with your address? Nothing. You played a con game of let me give a fake address so I can go ahead and play a mind game with the court system. Stop it. Stop it.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you've provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
And that's exactly what you're doing.
So you're not going to send it to the proper address. Okay.
Did that get sent, Ms. McDonald?
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right?
So my email, I'm using the same.
Go off camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
I'm dying to hear the excuse he's about to give for this nonsense.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get.
You know how to make up a bunch of bullshit ass excuses, though. It's 2025, dude. Either you playing stupid or you are stupid. It's either one or the other.
Back on it.
Okay. One moment.
Are you reviewing the document that Ms. McDonald sent to you?
Okay, cool. Got it off mute. Oh, so I see everything that you've sent over. Obviously, I'd probably have to look at it longer to make sure I
I'm asking you
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I mean, I've gotten through some of.
That ain't gonna take no time. All you gotta do is say, yes, do you take the plea bargain? No, you don't take it. He's trying to find ways to prolong this. I need time to. How long you need it? The court's gonna basically tell you, hey, this is what you're charged with. This is what we're willing to drop. This is what here's the plea bargain deal we have. They're not gonna send you 150 pages of stuff to read. He's again trying to play the Jedi mind trick. And it's going to end up not in his favor, I hope. But we will find out sooner or later. So we're going to continue this.
But for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that. But, if you do, I don't mind, taking the time to fully get into it.
Ms. McDonald, you're on mute.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh, no.
Well, if you don't wish,
See, cat and bait. He don't want to. He wants to prolong the trial, but he doesn't. He refused to waiver the speedy trial because what he's trying to do is count out the time. So he's like, "Oh, you didn't try me within a certain time frame, even though I'm playing these Jedi mind tricks." They already know the game you're playing, boo boo. It ain't working, and you on a. Everybody else is on a PC and you on a fucking iPhone. Anyway, let's go ahead and continue.
to waive speedy trial, then
Well, if she doesn't want to give me more time, then I guess we just got to.
Well,
you
the
know.
problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week, but if you want to take advantage of the city's
On the
offer,
11th,
right, if you want to take advantage of
9 a.m.
if you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
You ain't
I don't know that these are necessarily conversations to have on the record, but
if you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Absolutely.
Okay, how does that work?
Idiot.
How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I
Something
need it? Okay.
pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
How would I come back though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room. Prosecutor McDonald is inviting you to join room 1. So I
Yes.
just click join.
Yes.
Jonathan Schuster, 4A0525748. Mr. Schuster had an opportunity to speak with Ms. McDonald in the breakout room. And Ms. McDonald, where are we?
Yes, Your Honor. I'm a little bit concerned because it didn't appear that Mr. Schuster was, and I was kind of having a hard time discerning whether or not it was a willingness or an ability to track the conversation.
Oh, objection. I
Oh.
definitely have the ability to have a conversation and track what's going on. I offered her a counter and she didn't want to take it. And so that's where we are, ma'am.
So I do have some concerns there. Also, Your Honor, I did just pull up his criminal history. It appears that he does have an active warrant out for his arrest for a DUI.
Active warrant.
SMC bench warrant from 2/14/25.
Yes, that is the one.
Lock him up.
So I have a couple of concerns. The concern is the defendant is saying he doesn't have discovery. He has not read the reports. I asked him several times if he was prepared to proceed to trial on all 3 charges next week.
And I told her 9 o'clock on the 11th.
He is probably the dumbest MF I've ever met. Most people, if this, we talking about traffic violation. We're not talking about. I don't know what the traffic violations are. We talking about a traffic. It's going not only is it going to save you money, time, effort. It may bust him in his derriere if she's trying to hit him with a non-driver or driving without a license. That can be problematic. But he did it to himself. And she gave him a plea bargain. And he's still defiant. For whatever crazy, I'm not sure what's going on with his head. At first I thought that was a bonnet or something on his head, but yeah, he ain't the brightest fruit off the tree. But let's go ahead and continue.
I will be there.
So, yeah.
Mr. Schuster, that you're intending to go to trial without.
Right. And you're saying there's an open warrant? Is that King County? Is that who that's with?
So, Mr. Schuster, the Seattle Municipal Court issued a bench warrant for $5,000 on February 14th, 2025.
Okay. And so I'll need to obviously reach out to them so that we can get that quashed and taken care of.
That is true. You will need to do that.
Which I will do as soon as we're done here.
My expectation, if we're having another hearing next week, is that you will have done that before the next hearing.
Oh, 100%. No need to be walking around with warrants. That is unacceptable.
So, Ms. McDonald, are you raising 1077?
Well, I would ask that the court engage in a colloquy because like I said, I was having a difficult time assessing that because I don't know if it's an inability to track it
Objection.
appropriately or if it's unwillingness.
So Ms. McDonald is asking that I ask you some questions to make sure you're able to proceed.
Objection, Your Honor.
Mr. Schuster, there's nothing to object
It's been
to.
on the record. I'm ready for whatever we need to do on the 11th outside of quashing this warrant that I just recently found out, as you said it. I didn't even know that was a thing. So now I have to just take care of that. The 11th, I will be there at 9 a.m.
So Mr. Schuster, I'm going to ask you some questions. First and foremost, do you know what happens at a trial?
Do I know what happens at a trial? Yes.
Can you describe that to me?
What happens at a trial where we meet and go over the facts and determine whether or not that I will be charged with the allegations against me?
So who decides whether you're guilty of the allegations against you?
Well, of course, it's a trial jury.
So who's on a jury?
Well, my people. I mean, it's the people of, it's the people. Obviously, it's a jury trial.
Do you know the difference between a
It's the people of your peer, dumbass.
bench trial and a jury trial?
Yes.
What's the difference?
One, there's people who make the decision, and one, the bench makes the decision.
And who's the bench?
Well, I believe I'm speaking with her currently.
So the judge is the bench.
I'm the magistrate.
What are you charged with right now?
You want me to say it off my memory or read the actual
Tell me.
charges from because I have my paper. I can go get it real quick so I can
I don't
read
need
it.
you to read it to me. I need you to tell me to the best of your ability what you're charged.
Okay, yeah. You're charging me with, or the allegations are driving with a license suspended, 3rd degree, no interlock device, failure to comply. Is that correct?
Correct.
So, not only your interlock, which is usually he got caught with drinking and driving, he got a suspended license, which he most likely knew his license was suspended because he has an interlock device. And so, and the third one is, I forget what they said it was, not to comply or something of that nature. So he's an habitual offender. They shouldn't be writing off anything. Throw his ass under the bus and let's see him, or let's take him out to the barbecue and let's see if we can make some bacon. All right, guys, let's go ahead and listen to this.
Yes.
You know what the maximum penalty for each of those charges is?
Not off the top of my head, no way. I'd have to look at my notes.
Do you understand that DWS 3rd degree is a misdemeanor punishable by 90 days in jail and a $1,000 fine?
I understand the allegations against me, correct.
And that there's also a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine?
I do understand the allegations against me.
What would the city have to prove if you went to trial?
That the allegations are true. They'd have to have an injured party, show that the allegations are true. And, of course, they'd be able to...
They'd love to use the injured party, but this is a traffic violation. The injured party is the state that she's in. And they think that the injured party is actually have to be a physical person. It is a physical person. It's whoever representing the state. This is the delusion of how they think they can manipulate the laws to benefit them. So let's go ahead and get
present their beliefs over to the jury, and the jury decides. I'm not sure what we're doing here. I mean,
Asking you questions about the trial process to make sure that you understand the trial process.
well, I have the right to present myself in court, and that's what I'd like to do.
Ms. McDonald, I'm not getting enough to raise 1077 at this point, but I do understand your concerns.
Right.
I have concerns over Prosecutor McDonald and her ability to understand what's going on, but that's okay. I'm not going to raise any challenges or anything against that.
You
I
don't,
just want that noted. But regardless, I did give her a counteroffer, which was very reasonable. She declined, and so
Yeah, reasonable is subjective, and you're a solid citizen. Your reasonable is like, let's discharge all of it, and I don't get punished for nothing I done wrong. I'm almost willing to bet you $1 when he said, "Oh, drop all the charges, and I give you $1." You drove without a license, you drove without an interlock, and you drove without compliance. And what do you expect out of that? Do you expect to walk away free and not get punished at all? So you can turn around and do the same thing all over again? No. Prosecutor McDonald, throw the book at him and then throw gasoline on him and throw a match on him. Lock his ass up.
the next step would be, I mean, for this court would be the 11th at 9 a.m. Is that correct? Is that the right time?
that's correct. Ms. McDonald, do you have the ability to send over the electronic discovery to the courthouse for Mr. Schuster to pick up?
So we would have to, so the electronic discovery, we have the body worn camera and all of that information, that had to be burned onto CDs and sent to him because it's too large to send
You said
via
CDs.
email. So that was all sent out to his address. We would have to
You
redo
said
all of
CDs. You said.
Yes. Some of the body worn cameras on CDs because it's too large to send any other way, Mr. Schuster.
You still use CDs. Is that what that is wild.
Well, you are held to the same standard as attorneys, and attorneys are expected to.
I'm just surprised that you still use CDs.
Is there anyone that your office could, ABC Legal or something like that your office could get that over here quicker than the US mail?
Well, we would certainly be able to bring it to our office. Isn't that far from the courthouse, so it's not a difficulty in the transportation. It's just it would take my office probably the better part of the afternoon or tomorrow morning to get all of those burned to another set of CDs because there are several.
So if I ordered that your office bring a set of discovery here for Mr. Schuster to pick up after 10 a.m.
All right, his objection is about getting burnt to CDs, and here's what I'm going to have to say. CDs are literally invulnerable to be it magnetic fields, electric shock, things of that nature. I mean, yes, they can be snapped in half if not properly handled. But the problem with USBs is that an EMP can wipe a USB. And then, or you have corruption and things, which you could have also with CDs. His complaint is probably he don't have a CD player, or he claiming that he don't have a CD player. I still have a CD player, even though most of my devices don't support them. I have one that plugs right into the back, and boom, I have a CD. I need it because sometimes I burn stuff on, Blu-ray to back up stuff. It's still feasible. And it have a shelf life of 10 years or greater, depends on the quality of the CD. His problem is that he's still trying to find an excuse why not to accept this information that he needs so he can continue prolonging his case and hopefully to go past 90 days. But yet, he wants the stuff mailed out to him, but he doesn't want to reject or submit to the speedy trial, which is 90 days for the case that he's under. So basically, we already know what he's plotting. He's trying to push the case out past 90 days and say, okay, I didn't get a speedy trial. All this needs to be dismissed. But the courts know exactly what the game he's playing. And despite he wants to play stupid, which he kind of does look like he's kind of stupid, this sovereign citizen stuff never works. But let's go ahead and continue.
On Friday, would that be doable?
I would think so.
Okay, so Mr. Schuster, I'm going to have Ms. McDonald's office make you another copy of the discovery, burn the electronic medium onto CDs, and it's going to be available for you here at the court window after 10 a.m. on Friday. That is going to be the only additional discovery that you get. You need to find a way without driving to get here or get someone here to pick that up for you. That will be the only additional copy of the discovery for you. We'll be here at the courthouse for you to retrieve. The courthouse is closed on Saturdays and Sundays. So if you want to prepare for your trial, I recommend that you come Friday after 10 a.m. to do so.
They got you. They got you.
And I'm wondering if we can just pass this for a moment so that Mr. Schuster, I would ask that he read the plea form through in its entirety, because I think that does impart some of the things that he needs to take into consideration, which I don't think that he's necessarily considered, while we take the plea on the Partido Garcia matter.
I'm ready to proceed to trial on the 11th. Outside of quashing the warrant with, you said it was Seattle Municipal or King County?
Seattle Municipal Court.
Seattle Municipal. Outside of quashing that warrant, I am ready. I do have one question though. This is a criminal matter, so who was the injured party exactly?
The City of Lake Forest Park has filed
City
charges.
of Lake Forest Park. Okay, and they'll be present at the trial. I'll be able to face them.
They are represented by Ms. McDonald's office.
So the city is the plaintiff as well as the judge. Is that what you're saying?
The city is not the judge.
Lake Forest Park is not the magistrate for this matter?
Lake Forest Park is the municipality in which this court takes place. Judge Grant will...
Dude, learn the court laws. There's a slight separation. All right, so the police lock you get charged. Then it moves over to the prosecuting department. They determine if it's legitimate and the one to proceed with charges. Most cases it gets done. Then the court system, which is separate, then sets up a court date so you can go ahead and have your hearing done and your rights protected. He wants to write a whole different system so he can eradicate both or say, oh, you're both the same thing. Yeah, it's not, dude. It's not. You've been drinking too much of the sovereign citizen non-Gatorade nonsense. And yes, Gatorade Zero is a wonderful drink. Except for this nonsense he's preaching. Right? And that's going to continue.
likely be here next week. She is the judge. She does not represent the city. The city is represented by Ms. McDonald's office.
So the judge doesn't work for the city at all, is what you're saying?
She is a neutral arbiter of matters. She is not representing the city.
So she doesn't work for the city?
No, she works for the courts and the court system.
Ah, okay. And
So, Ms.
during
McDonald-
trial, the prosecution will be able to bring the injured party forward, correct?
During trial, the prosecutor will be afforded the opportunity to bring forth its witnesses. I suspect that will be.
No, I'm saying the injured party.
I'm talking, Mr. Schuster. Okay.
Oh, I hear you.
See, he's using the injured party thing. It's going to be individual, not the state. The injured party is the state, or who representing the state. Again, too much lead paint or mother. He's either a couple of things I'm going to explain. Too much lead paint, mother drunk too much alcohol while she was carrying him, or smoking too much weed, and or he just got dropped on his fucking head way too many times. Let's continue, folks.
I just wanted to make sure it
The
was clear what I
prosecutor
said.
has the ability to bring forward its witnesses. They have the right to cross-examine any witnesses that you bring forward. You are allowed to bring forward witnesses at no expense to you. You do have to comply with the court rules in terms of giving Ms. McDonald notice of any witnesses that you intend to call. So you can't show up on the day of trial having not notified her of potential witnesses and suddenly
Okay.
it's on her.
Okay, I guess I wasn't clear when I asked you because I wasn't asking about witnesses. I was asking about the injured party.
There doesn't have to be a named injured party. The
Well,
allegation,
I have the right to face
you have the right to
to face the injured party who's
cross-examine.
making these allegations against me.
You have
And
the right to present
so
a case.
she'll be able to,
Mr. Schuster, stop. You have the right to present
Okay.
a case.
Thank you, Judge. He's too damn stupid to realize what he's talking about, which he doesn't know what he's talking about. He's still focused on the. Okay, I'm going to give you an example. If I assaulted you, you would be the injured party, which would then go to court to say, hey, this man here injured me. You got pulled over for a traffic violation. The injured party is the state who wrote the rules saying that you are not allowed to do this. He's looking for a individual that was injured. The injured party is the state that you violated the law in. And because his brains is made of putty, he doesn't quite realize. Actually, he might realize this and just trying to play the Jedi mind trick. Or he's just so stupid, or he's been trained, or some website has fooled him into believing that certain laws have to have an injured party. And yes, they do. But the injured party can also be the state, not an individual. If you got charged for murder, there would be an injured party. The person you fucking murdered. If you assault somebody, there would be an injured party. It's the person that you injured. If you violate a traffic violation, there would be an injured party. It would be the state, because you violated the state policy on the laws that you decided you want to do whatever you want to do because you want to do it. That's what he's trying to use, but he's using it improperly. The injured party is the state, and the state can have representatives, being the police officer, or the prosecuting attorney officer. If they want to verify they did it, they'll go get they'll subpoena the police officer. And in certain states the police officer is going to show up anyway. Certain states you have to subpoena the police officer to bring him into court to debate the traffic violation. But either which way, the injured party in his case is the state. But he's trying to narrow it down to an individual. No, the state isn't an individual, it's a group. It's like a flower. Oh boy, if he had brains, he would blow himself up.
Case on your own behalf. You have the right to hear and call witnesses at no expense to you. You have the right to question the city's witnesses. Okay, you have the right to cross-examine their witnesses, but
I also have the
there
right
does
to
not have
face
to
somebody
be a
who's
per se
alleged.
injured party, which is what you're.
If you want to write to somebody as an injured party, we can get the police who are the citation. And what the hell you gonna say after that? Nothing. I didn't injure him. How did I injure the police officer? It still goes back to the state who set the laws. He's trying to circumvent the laws of the state. Dingleberry.
Getting
Well,
at.
I mean, in a criminal matter, there definitely needs to be an injured party.
Your Honor, perhaps we could take the plea and get the interpreter out of here, because I think Mr. Schuster's might take a little bit longer.
Oh, I mean,
We're gonna pass on Mr. Schuster's matter and take.
I'm done. So, I mean, is there anything
You're
else?
not done, you're not done, Mr. Schuster. You're gonna stay
Oh.
up, and we're gonna take this plea so that we can get Mr. Interpreter out of here. And then we'll
Oh,
come back to
okay. You wanted to talk with the other one. Okay, yeah, I can wait
Okay.
for them to finish so that we can
Great.
finish this up.
Let's do that. Record on Mr. Schuster's case.
I think so.
So this again is Jonathan Schuster, 4A0525748.
Yes, I am here.
So when we last left off, we were, I believe, setting this for trial next week.
Yeah. I did want to clarify some things from earlier, if that's okay with you, ma'am.
Okay.
Oh, shit.
Because you had denied both of the motions, and I just want to make sure I understand correctly why they were denied. So, would you be able to repeat that, please?
So again, as I stated before, your motion to dismiss is based on an allegation that this court does not have jurisdiction over driving offenses based on the right to travel articulated under the federal and state constitutions. The federal and state constitutions do not limit the states and municipalities' rights to impose traffic laws or driving requirements such as driving licenses and things like that. So there's no federal preemption of these laws. They are appropriately codified and appropriately enforced in the city of Lake Forest Park. So there is subject matter jurisdiction that this court has based on the fact that these offenses are alleged to have occurred in the city of Lake Forest Park. There's subject matter jurisdiction because this court is authorized by statute to function and to enforce these laws. And so for those reasons, your motion to dismiss is denied.
Okay, and so essentially, it's because they don't limit the state municipalities' ability to impose driving statutes. Is that correct?
Yes, you've cited the right to travel broadly articulated in the federal constitution. But nothing about that is contradictory to Washington's right to impose driving licensing requirements, and nothing about that federal constitutional law prohibits the city of Lake Forest Park from enforcing traffic regulations.
Okay. So it was denied because they do not limit the state's municipalities' ability to impose driving regulations.
So this court does have subject matter jurisdiction. We will be going forward unless you want to enter a guilty plea today with a trial next week. Is this going to be a bench or a jury trial?
Oh, a jury trial, for sure.
What's that? Okay. So we will set this for a jury trial next week. Again, Mr. Schuster, discovery will be available to you at the counter at the courthouse after 10 a.m. on Friday. It is the court's expectation that if you want to review that prior to trial, that you come down here and pick it up. There's not going to be a third mailing of discovery to a new address. The court's not going to entertain next week any kind of arguments for continuances based on you not coming down here or having someone come down here and pick that up.
Okay.
Not going to keep mailing things to different places.
With the court
Okay.
setting an intervening pretrial for Monday as well.
We can certainly do that. We can set a pretrial hearing for Monday.
I won't be able to attend on Monday. Tuesday would be the soonest I'd be able to make it to court.
I would ask for Monday, and I would ask that it be in person, Your Honor. So that we can make sure that he's had the opportunity to review the discovery, and we can have those assurances prior to calling in a jury.
I am going to require you to be in court on Monday morning, Mr. Schuster, 9 a.m. in person.
I don't have the ability to make it on Monday, ma'am.
Why is that?
Well, first, I do have other obligations with work. Outside of that, I had set up transportation to make it up there because, as you both know, I don't drive. And so I had set up transportation for Tuesday specifically.
He said he don't drive, and you got a traffic violation. Dude, stop lying. We know you drive. You wouldn't have that drive without a license violation if you didn't drive. So okay, let's go ahead.
To make sure I'd be able to attend that. And so I have no problem attending on Tuesday. I just don't have the ability to physically get there on Monday. Outside, I mean, plus I have to work. Obviously, work isn't the main thing, but I just physically don't have the ability to make it there on Monday.
And you don't have to work on Tuesday. This dude is so. You see, I understand why his eyes are brown because he's full of shit.
Well,
That's only in his case.
then we will set this for Tuesday. Is the court's expectation that you're gonna come pick up the discovery? We're not gonna entertain continuance motions based on not picking up the discovery.
Of course.
Well, Your Honor, and the other reason that I'm asking that we set it for Monday and that he be required to come is we also have the Goodwin matter that we are still anticipating will be set for trial that week as well. And by then, we're going to have a lot more information. And I do want to ensure before we walk through the door on Tuesday morning to start trial that Mr. Schuster is prepared.
Ma'am, I'm ready outside of the warrant that was brought to my attention today, but during the recess, I actually had a chance to fill out the forms on the Seattle Municipal Court site. So
I'm concerned about the discovery and the body worn camera. And
since prior to the recess, I am 100% ready for Tuesday at 9 a.m.
My concern, Ms. McDonald, is, to his point, if he doesn't have transportation, I'm not gonna ask him to drive here.
then at the very least, do one via Zoom. I prefer it to be in person, but I do think that we need to have that.
If you need me here on Zoom, I can definitely do Zoom. That's okay with me. I just physically can't be there on Monday.
Okay. Then that's what we'll do. We'll set a pretrial hearing for Monday. You are authorized to appear on Zoom on Monday, but on Tuesday you are ordered to appear in person.
Wait a minute. You're gonna give him a Zoom on Monday, but he said he has to work. He don't look like the brightest candle in the bunch. So, what work is he gonna be able to do and still be on Zoom? But let's go ahead and continue.
Okay, and so this went from a readiness back to a pretrial, correct? And then Tuesday we go to trial?
Yes. So today was the readiness hearing. We're gonna set a pretrial on Monday, and on Tuesday will be trial.
Okay. Okay. And then, other than that, did you have anything else for me?
Anything else you need to address today, Ms. McDonald?
No, Your Honor, I was just double checking my officers. I think we're good on availability, so.
You said what now? Your offices were good on availability?
My officers, the witnesses that are going to testify?
Oh, gotcha. It was Carlsbad, I think, or something like that. Either way.
They're all listed in the report.
Gotcha.
And again, Mr. Schuster, the conditions of release in the meantime are that you make all of your court appearances, notify the court of any address changes within 24 hours, no criminal law violations, no driving without a license and insurance. I do expect you to address that Seattle Municipal Court warrant. I'm not sure if they'll be able to clear it by next week, but at the very least, there should be a docket entry indicating that you've set up a hearing to do so, and all other previously imposed conditions remain.
Are you familiar with Seattle Municipal at all, ma'am?
Yes, I am.
Because when I went to the website regarding warrants, there was a form for motions to quash warrants. Do you know anything about that?
I know that some warrants can be quashed administratively and some warrants you have to show up in person.
Well, just in terms of the process and how to make sure it's handled correctly. Because when I was on the site, essentially what I was getting, I just filled out the form and then submitted it, and then it sent me an email telling me that I would need to wait for contact. Does that sound correct to what you know?
The court normally will contact you to tell you if they can administratively quash the warrant or if they need to set a hearing. However, given the quick turnaround, I recommend you call them tomorrow and talk to someone at the clerk's office in person.
Oh, that's good advice. Thank you.
Okay?
He's trying to find
Okay, well, there's nothing on.
he's trying to find a loophole. So Knucklehead got a warrant. He has to be in person in court on Tuesday. They allowed him to Zoom on Monday. He's trying to find an excuse why he's not going to show up on Tuesday because they got his warrant and he doesn't want to go to jail. But let's go ahead and finish this up.
Else on my end, was there anything with you two?
Don't believe there's anything else today.
Okay, so Monday 9 a.m. correct?
Monday, 9 a.m. Zoom is okay. Tuesday, 9 a.m. in person.
Ow!
All right.
Ow!
I shall see you Monday. Thank you.
Have a good day.
You too. Bye bye now.